as far as section 5 where they have mentioned is concerned, is not applicable for filing a suit after the law of limitation. Section 5 of limitation to condone the delay is not applicable. It is applicable only to the application, petition, and appeals. But there are other provisions provided in the Limitation Act which can be excluded. That they have mentioned section 12 to 17, where it says, on different occasions, you are entitled to exclude that period of limitation. Section 12, when you are going to prefer an appeal or challenge a judgment and decree by filing a suit, then naturally you have to produce a certified copy of the judgment which you are challenging it. So 12 gives you the scope for excluding the time taken by the office for preparing the judgment and giving the certified copy to you. So which you can exclude out of the total period of limitation available to you. The time taken by the office to give you the certified copy from the date of filing the application for certified copy till you take that certified copy, that period has to be excluded. Section 13 is pertaining to pauper miscellaneous under Order 33. So when you seek for permission to sue as an indigent person without payment of court fees, from the date you file the application under Order 33 till that application is decided, if it is dismissed, court will refuse to give you permission to file suit without payment of court fees. Order 33 says that then the court should give him time to file the court fees. Section 13 says the time taken by the case, PMIS, from date of filing till the case is disposed of, PMIS is disposed of, can be excluded. That period can be excluded. Section 14. If you are wrongly agitating the case in a different forum, under the bona fide belief that forum has got power, that period can also be excluded. Even this will be applied in case where you have withdrawn the suit under Article 23 Rule 1 with a permission to file the fresh suit on the same cause of action. So there may be a certain period gap which may affect your period of limitation to file the fresh case on the same cause of action, but you can make use of section 14. No, I was agitating my matter in that case, bona fide thinking that it has got power, but that has been returned, or technically it was not valid, therefore I withdrew it. So you can invoke from the date of filing of the suit, fresh suit, and till you withdraw this, you are permitted to withdraw. That period can also be excluded. Section 14. And courts have applied this not only strictly speaking to the court, even to authorities also. If you are agitating your matter in a different authority and there afterwards you come to know that it has no power, then also you can invoke section 14 of the Limitation Act to exclude. Then comes section 15. If the party is prevented from filing a suit by any order or injunction, or you are required to issue a notice, statutory notice, section 80 of the Code of Civil Procedure against government. So when the stay was operating till it was vacated, that period, and period of 60 days in issue of notice to the government when you file a suit against government, it can be excluded under section 15. Section 16 speaks with regard to when the party is a minor, the cause of action still yet to start till he gets actual right. If he is a minor or there is a death, his LRs have to take action. So then you can invoke section 16 of the Code of Civil Procedure for exclusion of time. Next comes section 17. When you are not aware, knowledge comes into picture now. A sale deed come into existence without your knowledge, your client's knowledge, pertaining to your own property. As though you have not executed that sale deed, by playing a fraud, the sale deed has come into existence. So then also you can invoke section 17. From the date of knowledge, the limitation can be calculated. So this is how you have to answer, because the marks is 8. So you have to give some details and examples for this question 3, sub question C. Then comes D, that is pertaining to when an order of attachment before judgment is made under Order 38, Rule 5 CPC, what is the impact of Rule 10 of the same order? Attachment before judgment, Order 38, Rule 5. The court cannot grant attachment before judgment directly, it has to issue a show cause notice first. The plaintiff has to make out a case that defendant is trying to remove all the properties belonging to him from the jurisdiction of the court in which he is filing the suit or has filed the suit, with an intention to defeat the plaintiff in enjoying the decree that may be passed. So once the court feels or satisfied, the court has to first issue a show cause notice, then hear the defendant. Then if he furnishes security, fine, or if he shows to the court the contention of the plaintiff is not correct, he is not removing any article or property from the jurisdiction of the court, there ends the matter. Court will dismiss. Otherwise, court will order for attachment. Rule 10 says, when the court passes an order of attachment before judgment, it will not affect the earlier alienation or attachment. By the time the order of attachment is made, if the defendant has already alienated the property or encumbered the property to somebody else, then on those alienation or those encumbrances, the attachment will not have any effect. That is the Rule 10. Next, 4A, state the law relating to decree in preemption suit under Order 20, Rule 14 CPC. B, mention the date of cause of action for filing a suit claiming the right of preemption with reference to sale agreement of the subject matter by a person against whom preemption is claimed. C, state the meaning of the terms pro forma defendant and pocket defendant. D, counterclaim and application for alimony. E, what is the legal position in respect of judgment on admissions under Order 12, Rule 6 of the Code of Civil Procedure? Now, preemption. Order 20 gives how in a particular type of case, the court has to pass the judgment. It deals in detail. Specific performance nalli yav ರೀತಿ ಮಾಡಬೇಕು ಜಡ್ಜ್ಮೆಂಟು, ರಿಕವರಿ ಆಫ್ ಮನಿ, ಮಾರ್ಟ್ಗೇಜಸ್ಸು and preemption. As far as preemption is concerned, it says the court has to first ascertain what is the amount the plaintiff is required to pay for purchasing of the property. So preemption right, as we know that in a co-personary properties, normally there will be a clause or agreement, even including partition. If one of the party to whom the property is given wants to sell, first he should ask the other co-partners. If they are not ready to purchase the property for the market value, then they should go to others. Reason behind this is the family property should not go to others. They will be having an attachment. So in that preemption suit, the party should ascertain, the court should ascertain what is the amount he has to pay and when he has to pay, within what time. That should be enumerated in the judgment of the court. Then also, if he fails to pay the amount to exercise the right of preemption, if another person is there in the suit, court should mention. If D fails, he should be given the option to purchase the property. So that is how we have to deal with regard to decree. And with regard to cause of action, Article 97 of the Limitation Act deals with regard to limitation and cause of action in a preemptory suits. Article 97. 1 year. It has to be exercised within 1 year. That is what it says. Yavattinda ಒಂದು ವರ್ಷ, this is what it says. When the purchaser takes under the sale sought to be impeached physical possession of the whole or part of the property sold, or where the property sold or where the subject matter of the sale does not admit of the physical possession of the whole or part of the property when the instrument of sale is registered. So on physical possession ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾನೆ ಅಂತ ಹೇಳಿದ್ರೆ, even in agreement, then the time starts, 1 year starts on physical possession ತಗೊಂಡಾಗಿಂದ ಶುರು ಆಗೋಗುತ್ತೆ. ಇಲ್ಲ physical possession ತಗೊಂಡಿಲ್ಲ, then the second portion of this Article 97, when the instrument of sale is registered, ಆವಾಗ ಬರುತ್ತೆ, ಆವಾಗಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ 1 year. ಸೇಲ್ ಯಾವಾಗ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೋ ಆವತ್ತಿಂದ ಮಾಡಬೇಕು. State the meaning of the terms pro forma defendant and pocket defendant. This also we have examined on earlier occasion. Pro forma defendant is only defendant against whom no relief is claimed. He is only a proper party. ಅವನ ಮೇಲೆ ಏನು ಪರಿಹಾರ ಕೇಳಿರೋದಿಲ್ಲ. He is only a that is why when a suit is decided where there is a pro forma defendant, in the next suit, even though it is pertaining to same subject matter between the same parties, the courts have taken the view it will not, the principles of res judicata is not applicable with regard to pro forma defendant. If no relief is claimed, unless it is otherwise proved. Pocket defendant, as I said, it is not in vogue in our country. In England normally deep pocket anta karitare avaniಗೆ, ಅಥವಾ sourceful person, even though he is not directly responsible for the relief sought by the plaintiff. Court, sometimes some courts used to put liability on this defendant who is having source deep pocket ಅಥವಾ ಪಾಕೆಟ್ ಡಿಫೆಂಡೆಂಟ್ ಅಂತ ಕರೀತಾರೆ ಅವನು. ಇನ್ನು ಡಿ, similarities between counterclaim in a suit and application for alimony by the wife in case filed by the husband for divorce. What is the effect of dismissal for default of the case filed by the husband? This also we have examined. Normally they are same except for the fact that you need not pay court fees in the maintenance. Court fees ಕೊಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ ಅಲ್ಲಿ. In a maintenance case, in a divorce case, that is what they have said. In a divorce case, when the wife asks for maintenance, either she can ask for interim alimony or permanent alimony. Interim alimony cannot be termed as a counterclaim. Only permanent alimony under section 25 of the Hindu Marriage Act will be or can be termed as a counterclaim. Because interim alimony is only during the pendency of the case petition. In counterclaim, you can seek for the counterclaim when it is ascertained sum, and the court in which you seek should have the jurisdiction to grant you the claim, and it should also have the limitation. Whereas in the maintenance case, there is no court fees required. Permanent alimony, a limitation ಪ್ರಶ್ನೆನೂ ಬರಲ್ಲ ಅವಾಗ ಅದರಲ್ಲಿ. ಆಮೇಲೆ ಇಂಪಾರ್ಟೆಂಟ್ ಥಿಂಗ್, ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಇಫ್ ದಿ husband petition for divorce is dismissed? As I said already, if there is a application filed by the wife for permanent alimony under section 25, even though petition filed by the husband is dismissed, court is bound to decide that permanent alimony. There is a difference. What is the legal position in respect of judgment on, next question, admissions under order 12 rule 6? You may remember that even under order 8 rule 10, where the defendant fails to file the return statement, court has got right to proceed with the decreeing the suit. Even though they have used the word decree the suit, the courts have taken the view merely because the defendant has not filed the return statement, court need not decree the suit. If it feels, court can ask the plaintiff to prove. Similarly, when under order 12 rule 6, if the parties have admitted a particular relief, on that basis itself the court has got power to decree the suit based on the admission, decide the case. You can look into decision if you want to know details with regard to order 12 rule 6, 2000 part 7 Supreme Court cases, SCC, page 127, 2000 part 7 SCC 127. So even we can seek for partial decree also if the court feels that. Of course, discretion is given to the court. Court can refuse also, remember. Court has got discretion either to decree the suit or not on the basis of the admission under order 12 rule 6. Then we'll go to other questions pertaining to 9. Question 9. ನಲ್ಲಿ ಬಿ ಎನ್ಆಕ್ಟಿಗೆ ಸಂಬಂಧಪಟ್ಟದ್ದು. ವೆರಿ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಒನ್. where agreement of sale was in question. Ramappa sells 2 acres of land bearing survey number 40 at Attibele to Rajanna for 2 lakhs. And issues a check bearing number so and so for 2 lakhs on the same date to Ramappa. On the presentation, the check gets dishonored. Thus, Rajanna fails to pay the agreed consideration for the land. Ramappa initiates proceedings under section 138 of NI Act and also files a suit for cancellation of sale deed on the ground of want of consideration. Briefly explain the law in this connection. ಬ್ರೀಫ್ಲಿನೇ ಮಾಡಬೇಕಾಗ, ಯಾಕಂದರೆ ಅವಳು ಮಾರ್ಕ್ಸ್ ಇಟ್ಟಿರೋದು ಬರೀ 3. Only 3 marks has been given. Now you see, 2 cases are there. One is NI Act 138. So if a check is issued, presumption arises in favor of the holder of the check. Check is issued to him for a consideration. Lawfully legal debt. It is lawfully liable to pay legal debt. So here it is very clear. He was entitled to 2 lakhs. Towards that, he has issued this check. So it is attracting section 138 of the Negotiable Instrument Act, that petition is maintainable. Simple. Now, with regard to suit, sale deed, cancellation of sale deed. For this, the courts have taken the view, even Supreme Court, very detailed examination of the TP Act. The courts have taken the view, even the consideration not given and the sale deed is executed, unless there are specific terms in the contract or sale deed, the sale is complete. You cannot seek for cancellation of sale deed. The seller cannot seek for cancellation of sale deed. Only remedy available to him is to file a suit for recovery of money. So the second suit is not maintainable, because it is presumed that once the sale deed is executed and registered, there ends the matter, unless there are specific terms in the sale deed. ಚೆಕ್ಕು ಡಿಸಾನರ್ ಆಗಿದೆ, ಹಣ ಬಂದಿಲ್ಲ ಅಂತ ಒಂದೇ ಒಂದು ಕಾರಣ. ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಕ್ಯಾನ್ಸಲ್ ಆಗೋಲ್ಲ. ಸೊ ದಟ್ ಈಸ್ ಹೌ ಯು ಹ್ಯಾವ್ ಟು ಆನ್ಸರ್ ದಿಸ್. ನೆಕ್ಸ್ಟ್ ಇನ್ನೂ ಪೆಕ್ಯುಲರ್ ಕೇಸ್ ನೋಡಿ. ಸಿ, ಕಿರಣ್ files a suit against Charan at Sandur Court for declaration of title and consequential relief of permanent injunction over a vacant site in the limits of Sandur. Charan fails to attend court deliberately. He is set ex parte by the court and finally his suit is decreed ex parte. Charan files an application under order 9 Rule 13. The said application is also dismissed. Charan prefers an appeal against both the orders of placing him ex parte and suit being decreed ex parte. Do you concur with the legal advice and the steps taken by Charan of preferring an appeal against both orders? ಒಂದು application under order 9 Rule 13 dismiss, ಅದ್ರ ಮೇಲೆ ಅವನು ಅಪೀಲ್ ಹಾಕಿದ್ದಾನೆ, ಮಿಸ್ಲೆನಿಯಸ್ ಹಾಕಿದ್ದ, ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಡಿಸ್ಮಿಸ್ಡ್. ಸೊ ಡಿಸ್ಮಿಸಲ್ of an application under Order 9 Rule 13 is an appealable order under Order 43. At the same time, he has also filed an appeal against the ex-parte judgment and decree. Is it maintainable? What do you say? Again, the Supreme Court has examined these aspects, where it says that there is no bar to the defendant to invoke Order 9 Rule 13 as well as Section 96 filing an appeal. But only explanation under Order 9 Rule 13 is, if he files an appeal and if it is dismissed on merits, then his remedy under Order 9 Rule 13 is barred. But if he files an appeal and he withdraws appeal, then he can invoke again Order 9 Rule 13. Because under Order 9 Rule 13, the ground which is available to the defendant is summons is not served. Whereas under Section 96, he can challenge on merits the ex-parte judgment and decree. That distinction has been made by the Supreme Court and said that he can invoke both. But once the appeal is disposed of on merits, finished. The appeal is not, miscellaneous petition cannot be filed. But here, miscellaneous petition is dismissed, but appeal is provided. So he has invoked that. Both are now pending. Appeal against Order 13 Rule, Order 9 Rule 13 order and ex-parte judgment and decree under Section 96. So both are maintainable, but if appeal filed under Section 96 is dismissed on merits, automatically the ex-parte judgment merges with the appellate court order judgment. Law of merger, it is known as law of merger. Then the miscellaneous filed under order, appeal filed under Order 43 against the order passed under Order 9 Rule 13 is nowhere there. It has already merged with the appellate court judgment. Hence, this appeal will become infectious. ಅದಾಗಿ ಬಟ್ ಎರಡೂ ಪೆಂಡಿಂಗ್ ಇರೋದ್ರಿಂದ ಎರಡೂ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೋದು. Both he can prefer appeal against ex-parte judgment and decree and also rejection of his application under Order 9 Rule 13 he can prefer. With that you can write 4. Marks is 4. ಇನ್ನೊಂದು very peculiar question. I am exceeding my time. I think ಇದೊಂದು ಮುಗಿಸ್ಬಿಟ್ರೆ I think this is the last question. I think 2016 question paper na ಮುಗಿಸ್ಬಿಡೋಣ. That is the last question. Okay, this will be the last for the day. On 1/1/2012, Krishna files a suit for permanent injunction against Rama in respect of a residential site number 14 at Magdi to restrain the latter from proceeding with construction over the said site, claiming that Rama has entered into an agreement on 1/12/2011 agreeing to sell the said site for 20 lakhs to Krishna and received an advance amount of 2 lakhs from Krishna, thereby agreeing to execute the registered sale deed at any time on demand by Krishna, provided balance consideration is paid. The return statement dated 1/2/2012 time dates are important. 1/1/2012 ಕೇಸ್ ಹಾಕಿದ್ದು ಇಂಜಂಕ್ಷನ್ಗೆ, 1/2/2012 ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ಡ್ ಬೈ ಡಿಫೆಂಡೆಂಟ್ ರಾಮ denies execution of sale agreement and further contends that Krishna has played a fraud. After the trial, the case is posted for judgment to be pronounced on 25/6/2016. ಜಡ್ಜ್ಮೆಂಟಿಗೆ ಹಾಕಿದ್ದಾರೆ 25/6. ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಡೇಟ್ಗಿಂತ ಮೊದಲೇನು ಮಾಡ್ತಾನೆ, ಕೃಷ್ಣ ಫೈಲ್ಸ್ ಎ ಸೂಟ್ 15/6/2016 ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ರಾಮ in respect of the said sale agreement regarding the site. Discuss the legal position. This is covered under a decision. General order 2, you should go to order 2, rule 2 and you see the 2013 part 1 Supreme Court cases, page 625. 2013 part 1 SCC page 625. ಆಲ್ಮೋಸ್ಟ್ ಐಡೆಂಟಿಕಲ್. ಅದರಲ್ಲಿ ಜಾಸ್ತಿ ಕೇಸಸ್ ಹಾಕಿರ್ತಾರೆ, ಇದರಲ್ಲಿ ಒಂದೇ ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ, ಅದರಲ್ಲೂ ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್. ದಿ ಜನರಲ್ ನೋಷನ್ hitherto before the passing of this judgment was to invoke order 2 rule 2, an earlier suit should have been disposed of. Then the plaintiff files another suit in which defendant takes up a contention on the same cause of action an earlier suit was filed. This relief ought to have been sought in that suit itself. ಆ ವ್ಯಾಜ್ಯದಲ್ಲಿ ಅವನು ಹಾಕ್ಬೋದಾಗಿತ್ತು ಅಂತ. The second suit is hit by order 2 rule 2. All the relief for which the plaintiff was entitled to should be sought in the same suit on that particular cause of action. That is what order 2 rule 2 says, unless he reserves the right to file a separate suit. If he has not reserved the right to file a separate suit, no. But in this particular judgment, the Supreme Court goes to the extent of stating that no, not necessary that earlier suit should have been decided or disposed of. No, even if an earlier suit is pending and the plaintiff files another suit, you can take up the defense under order 2 rule 2. He could have sought for this relief in that case itself. So here, when the suit for injunction was filed by the plaintiff alleging that the defendant has executed an agreement of sale and agreed to execute the sale deed at any time, now he is putting up a construction. But defendant has filed a written statement. No, it is a ಬರೆದು ಕೊಟ್ಟೇ ಇಲ್ಲ ನಾನು. It is a created document which shows that he has refused to perform the contract. Defendant. So that is how the period of limitation starts. In a suit for specific performance of the contract, either 3 years from the date of execution of the agreement or from the date when the vendor has agreed to execute the sale deed, or when the purchaser comes to know that seller has refused to execute the sale deed. ಅವನು ಮಾಡಿಕೊಡಲ್ಲ ಅಂತ ಅವನು ಯಾವಾಗ ಗೊತ್ತಾಗುತ್ತೋ ಅವಾಗೆ ಸ್ಟಾರ್ಟ್ ಆಗೋಗುತ್ತೆ ಕಾಸ್ ಆಫ್ ಆ್ಯಕ್ಷನ್. ಸೊ ಅವನು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆದ ತಕ್ಷಣ ಅವನಿಗೆ ಗೊತ್ತಾಯ್ತು ಇವನು ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಕೊಡಲ್ಲ ಅಂಥೇಳಿ. ಸೊ ಅವಾಗಲೇ ಅವ್ನು ಕೇಸ್ ಹಾಕ್ಬೋದಾಗಿತ್ತು, ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್. So from that date the 3 years starts. You see, 1/2/2012 ಅವನ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟಲ್ಲಿ ಹೇಳಿದ್ದಾನೆ ಮಾಡಿಕೊಡೋ ಕ್ರಿಯೇಟ್ ಆಗಿರೋದು ಮೋಸ ಮಾಡ್ಕೊಂಡಿರತಕ್ಕಂಥ ಒಪ್ಪಂದದ ಕರಾರು ಪತ್ರ. ಸೊ ಅಂದರೆ ಮಾಡಿಕೊಡಲ್ಲ ಅಂತ ಆಯ್ತಲ್ಲ. he has come to know that. From that day the 3 years starts. But he filed the case when 15/6/2016. 15/6. So he ought to have claimed on that case itself. ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ ಹಾಕಿದ್ನಲ್ಲ ಅದರಲ್ಲೇ ಕೇಳ್ಬೋದಾಗಿತ್ತು ಅವನು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿಕೊಂಡು, ಇಲ್ಲ ಅವಾಗಲೇ ಕೇಸು ಹಾಕ್ಬೋದಾಗಿತ್ತು. ಸೊ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟೇಕನ್ ದ ಸೇಮ್ ವ್ಯೂ. ದ ಸೆಕೆಂಡ್ ಸೂಟ್ ಈಸ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್. And in that case, Supreme Court ಕೇಸ್ನಲ್ಲಿ Fortunately, the suit for injunction was still pending. But ಇದರಲ್ಲಿ ಆಗಲೇ ಜಡ್ಜ್ಮೆಂಟಿಗೆ ಆಗಿದೆ, ಈಗಲೂ ಮಾಡ್ಬೋದು ಅವನು. The case is posted for judgment on 25/6/2016. He can invoke 151 and also seek for amendment also. But the problem is limitation, because it is barred by time. 3 years ಆಗೋಗಿದೆ ಆಗಲಿ. So that is how you have to answer this question to question number 10A. So these are the some of the questions in 2010 to 2016 which we have covered, including earlier classes, pertaining to the Code of Civil Procedure. Some of them are limitation and Negotiable Instrument Act in brief. So